Welcome to Bharathidasan University International Center counseling sessions. So let us start with third semester MBA sessions. So in this third semester we have 6 papers to learn, 3 papers from general streams and 3 papers from specialization. The 3 papers from general streams consist of business law, strategic management, and one more paper is there that will be called as business law, MIS, and strategic management. And the specialization 3 papers, that depends upon the specialization the students choose. And so today we will start with the specific topic called as business law. And let us see the syllabus. So in our business law, this is actually a law paper. It consists of several enactments like Indian Contract Act 1872, the Partnership Act 1932, the Companies Act 1956, etc. So these are the specific topics. First one is Law of Contract 1872, consists of the topics like agreement, offer, acceptance, consideration, capacity to enter into contract, contingent contract, quasi-contract, performance, discharge, and remedies in case of breach of contract. The second module consists of Indian Partnership Act 1932, Sale of Goods Act 1930, and Law of Insurance. The third module consists of some of the enactments like Negotiable Instruments Act 1881, specific topics like the promissory note, bill of exchange, crossing, endorsement, holder in due course, contract of agency. And the next 2 modules, the 4th and 5th module, is related to the Companies Act 1956. So 4th module consists of the basic topics about the formation of the company, memorandum association, articles of association, prospectus, shares, debentures, their appointment of directors, powers and duties of directors, etc. And the last module consists of company meetings like annual general body meeting, then extraordinary general body meeting, management, accounts, audit, then suppression and mismanagement. And last topic is how to winding up a joint stock company. See, these are the topics, these are the syllabus to be covered in our third semester business law. So let us start with specific topic called as the Contract Act 1872. The Contract Act 1872, it is enacted in the year 1872. This is actually a British law. It was enacted during the period of British period only, and till now we are following the same the Contract Act 1872 only. And almost all the Commonwealth countries also the Contract Act will be the same. So at the present day our modern economy, we can see almost all the business transactions is related to contract. That means it is related to agreement, it is related to offer and acceptance. We cannot imagine a business transaction without any kind of agreement. So see here in this Contract Act, we will discuss something related to the rules and regulations related to a contract consists of agreements and acceptance. So here in section 2, in every enactment in India, section 2 is related to the definitions. Whatever the specific terms used in this enactment, section 2 defines the specific terms. Like here in this Contract 1872, we have to discuss what is a contract, what is agreement, what is acceptance, etc. So here we will discuss one by one. So first one is definition of contract. Section 2 subsection H of the Indian Contract 1872 defines what is contract. So according to section 2 subsection H, contract is an agreement enforceable by law. So an agreement, whatever agreement which are enforceable by law, that will be treated as agreement. So we can say that all contracts are agreements, but all agreements are not necessarily contracts, because sometimes some agreements are not enforceable by law, maybe due to illegal or illegality, something like that. It is not enforceable. So we can say a contract is equal to agreement plus enforceability by law, and agreement is equal to, we can say agreement is equal to offer plus acceptance. And here we will discuss the terms like What is agreement? Section 2 subsection E of the Indian Contract at 1872 defines what is agreement. So according to section 2 subsection E, agreement is every promise or every set of promises forming consideration for each other. It will be called as agreement. So section 2 subsection E defines what is agreement. So according to section 2 subsection E, every promise or every set of promises forming consideration for each other will be called as agreement. An agreement or a proposal when accepted becomes a promise. A proposal when accepted, it will be treated as a promise. And in order to constitute a valid agreement, there should be consensus ad idem. So consensus ad idem means meeting the minds of the parties at the same time and at the same sense. Suppose there is no consensus, we cannot treat it as an agreement. For example, suppose Mr. A, he is owning two horses, one white color and another one is black color. Suppose he is offering white color horse to Mr. B, and Mr. B is accepting that I am ready to purchase black horse. See, in this case there is no consensus ad idem, because Mr. A is intending to sell white horse, but Mr. B is accepting the sale of black horse only. So in this case there is no consensus ad idem. So in this case we can say both the parties, Mr. A and B, they are making some counter offers only. Mr. A is offering horse A and Mr. B is ready to accept or purchase horse B. So this is actually from Mr. B side is only a counter offer to Mr. A only. So we can say agreement is equal to offer plus acceptance. And see, section 2 subsection A defines what is offer or what is proposal. According to section 2 subsection A, when one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent or the other, such act or abstinence, he is said to make a proposal. So this is the definition given by section 2 subsection A of the Indian Contract at 1872. So according to section 2 subsection A proposal means when one person signifies to another his willingness to do or abstain from doing something with a view to obtain the assent of the other to such act or abstinence, such act is said to be proposal. So in this case Mr. A is offering, he is offered to do something or to abstain from doing something. See, such offer to act or not to act or abstain from doing something with an intent to get a permission or a consent from the other person, such act or abstinence will be called as offer. And in order to constitute a valid agreement, acceptance is required. So section 2 subsection B of the Indian Contract in 1872 defines what is acceptance. So according to section 2 subsection B, an acceptance means when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. So without acceptance we cannot constitute an agreement. Acceptance is one of the most important element in order to constitute a valid agreement. So section 2 subsection, according to section 2 subsection B, when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal when accepted becomes a promise. See, the person, there are two parties involved in a contract. One is the offerer and the other person is offeree. A person who makes a promise is called as the promiser or offerer. The person who makes the offer will be treated as the promiser or offerer, and the person to whom the offer is made, that person will be called as the promisee or the offeree. So agreement does not become a contract unless there is a corresponding obligation, that is enforceability by law. So that is why we can say contract is equal to agreement plus enforceability by law. Some agreements are not enforceable, some sort of illegal agreements will be there. So we can say all contracts are agreements, but all agreements are not necessarily contracts. See, the next topic is characteristics of a valid contract, or features of a valid contract. So regarding, suppose we are talking about characteristics of a valid contract, section 10 of the Indian Contract Act, this is one of the most important section in the contract in 1872, because section 10 is related to the characteristics of a valid contract. So according to section 10, all agreements are contract if they are made by free consent of the parties competent to contract for lawful consideration and with a lawful object, and are not expressly declared to be void. See, this is the exact definition of section 10 related to the characteristics of a valid contract. So according to section 10, all agreements are contracts if they are made by free consent of the parties competent to contract for lawful consideration and with a lawful object, and are not expressly declared to be void. If you check this definition, we can see a lot of points to be covered in this definition. The first one is all agreements are contract if they are made by free consent of the parties. The first point is free consent of the parties. The second one is competent to enter into a contract and a lawful consideration with a lawful object, and are not expressly declared to be void. Section 23 of the Indian Contract Act describes some of the agreements which are expressly declared as void. So let us see the conditions of or features of a valid contract. The first one is free capacity of the parties. So section 11 of the Indian Contract 1872 defines what is capacity of or competency of a party to enter into a contract. According to section 11, every person is competent to contract who is of the age of majority according to the law to which is subject, who is of sound mind, and is not expressly disqualified from contracting by any law to which is subject. So competency to enter into a contract is very important. Only those persons who are competent to enter into a contract can create a valid obligations or a valid contract. A minor, a lunatic, a drunkard, see, these kinds of people are lacking some competency. They are not capable or not competent to enter into a contract. See, only major person and the people who are sound mind, they are capable to enter into a contract. So any contract with an incompetent person is invalid. The second point of characteristic, we can say free consent. See, absence of consent does not create any kind of legal obligation. So free consent, the minds of the parties should be free. It should not be induced by coercion, undue influence, fraud, or misrepresentation. Whenever there is free consent is missing, see, in that case such type of contract will be treated as a voidable contract. It is voidable or it is void at the option of the party whose consent is not free. The third point of characteristic, we can say lawful consideration and lawful object. A contract without consideration is void. So consideration means something in return. That means quid pro quo. Quid pro quo means something in return. So every kind of valid contract should be supported with some sort of consideration. Consideration need not be adequate. Consideration it might be past consideration, it might be present consideration, it might be future consideration. Even past and future consideration is also valid. An act or abstinence, maybe consideration may be an act to do something or not to do something, or even abstain from doing something is also a valid consideration. But a contract without or an agreement without consideration is void ab initio. See, these are the points related to the consideration. The next point is intention to create a legal relationship. So the another important characteristic, we can say the intention of the parties to create a valid consideration or a legal relationship. That is very, very important. Social agreements are not a contract at all, because there is no intention to create any kind of legal obligation. For example, a father of Mr. A promised to Mr. A some sort of pocket money, 500 rupees every month, and later on Mr. A's father, he is not able to comply his promise. So in that case there is one question arises: is Mr. A is in a position to file a case against his father or not? See, in this case, as far as the time of agreement is concerned, the father of Mr. A is having no intention to create any kind of legal obligation. So in that case, Mr. A is not in a position to file any case against his father in order to comply or in order to implement this kind of agreement, because this is only a social agreement. This is only a social agreement, and there is no intention to create any kind of legal relation. And there is one case study. There is, in order to substantiate this point, there is one case study called as Balfour versus Balfour. So in this case, a husband promised his wife a household allowance of 30 pounds every month. Later, the parties separated and the husband failed to pay such amount. The wife sued a case against his husband regarding implementing this allowance. So the court then declared that this is only a social agreement. There is no intention to create any kind of social relationship. So such type of contracts are not a valid contract. The next point of characteristic, we can say possibility of performance. See, the next important characteristic, we can say the agreement should be a possible one. See, impossible. See, in order to make an agreement or offer an acceptance for implementing some impossible things, it is void ab initio. For example, a promise B that he would make the sun rises in the west if B pays him rupees 1 lakh. So it is an impossible thing, because in order to make the sun rises in the west, it is an impossible thing. So in order to make such type of contract, it is invalid. See, such type of contracts or agreements are not an valid agreement because of due to the impossibility of any agreements which are impossible at the beginning. It is it shall not be treated as a valid contract. The next one is meaning should be certain. There should be a consensus ad item, and the meaning of the contract should be certain. And the next one is legal formalities if required. So in order to create a valid contract, for example, regarding then registration is required in order to transact some land or some kind of contract. In order to make a valid contract, it should be registered. It should be the stamp duty should be properly paid, etc. So whatever legal formalities required, such type of contract, both the parties should provide the legal formalities. Suppose the parties involved in this contract fail to make such kind of legal formalities, that agreement will be treated as an invalid one. The next one is agreement not declared to be void. See, as per the provisions of the contract in 1872, some agreements are expressly declared as void. Section 23 of contract in 1872 defines some or provides some agreements which are expressly declared to be void. Such a type of agreements are void ab initio, and it is not enforceable by law. See, these are the various characteristics of a valid contract. The next point of discussion, we can say kinds of contract. So according to the characteristics like the validity, according to the performance, etc., the agreements will be or contracts will be divided into like this. According to validity, agreements will be divided as void agreements, or similarly valid agreements and voidable agreements, or valid contract, voidable contract, and void contract. So what is valid contract? So valid contract means an agreement an agreement which fulfill the essentials of valid contract as per section 10. Suppose an agreement which will fulfills the essentials of a valid contract, such contract will be called as valid contract. And the next one is voidable contract. Section 2 subsection I defines what is voidable contract. According to section 2 subsection I, voidable contract or voidable agreement means an agreement which is enforceable by law at the option of one or more of the parties thereto, but not at the option of the other or others, is a voidable contract. Section 2 subsection I defines voidable agreement. So according to section 2 subsection I, an agreement which is enforceable by law at the option of the one or more parties thereto, but not at the option of other or others, is a voidable contract. See, this voidable contract is it's coming mainly because of the lack of free consent. Whenever in an agreement there is no free consent, such type of contracts are called as voidable contract. And the next one is the next type of contract, we can say void contract. Section 2 subsection J defines what is void contract. A contract which ceases to be enforceable by a law becomes void when it ceases to be enforceable. See, this is a definition of void contract. Section 2 subsection J, a contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. So that means see, some agreements or some contracts are voidable ab initio, and sometimes some contracts will be void later on, so due to certain impossibility of performance, etc. Sometimes of contracts, some contracts will be, sometimes it will be void. And see, these are the classification of contracts according to validity. According to validity, we can say contracts may be valid contract, voidable contract, and void contract. And the next classification is on the basis of performance. We can say contracts will be divided into contracts like executor contract, executory contract, and partly executor and partly executory contract. Before entering into this performance, we will discuss some other types of contracts like contingent contract. So contingent contract means a contract that is enforceable mainly occurrence of an uncertain or a future event, a contingent event. Contingent contract means the enforceability of that contract is valid or is happening only occurrence or happening of a future event only. Unenforceable contract, there is another classification called as unenforceable contract. Unenforceable contract means a contract which are unenforceable, which are not in a position to implement, which are not in a position to enforce it, mainly because of lack of some legal formalities. It might be not registered or not properly done. So in that case, such type of contracts are unenforceable. And the next form of classification, we can say on the basis of formation of contract, we can say contracts may be or agreements may be expressed contract,